Good afternoon, everyone. Thank you for joining us today. My name is Alyssa Gresh. I'm the Executive Director of the American Association of Jewish Lawyers and Jurists. The AAJLJ brings together lawyers, judges, scholars, and legal professionals committed to strengthening the rule of law and responding to the legal challenges facing the Jewish community. One of our central goals is to create spaces where leading thinkers and practitioners can share ideas, strategies, and legal tools to address these important issues of our time. Today's program, New Legal Tools to Fight an Ancient Hate, could not be more timely. Anti-Semitism has researched globally, including here in the United States, and for those of us in New York, certainly. And the legal community has an important role to play in confronting it. We're very fortunate today to be joined by Dr. Mark Goldfeder, CEO of the National Jewish Advocacy Center and a law professor at Touro Law School. Dr. Goldfeder has been at the forefront of some of the most innovative legal strategies addressing anti-Semitism, BDS, and material support for terrorism. His work spans litigation, policy advocacy, and international law. And since October 7th, he's been deeply involved in a number of significant federal cases targeting entities that have supported Hamas. We are grateful to Dr. Goldfeder for joining us today and sharing his insights on how the law can be used more effectively to protect the Jewish community. Just a note, if you have any questions, please feel free to put them in the chat and we will get to them hopefully after Dr. Goldfeder's talk. Mark, thank you again for being with us, and I will turn it over to you.
Sure. Good afternoon, everyone. Thank you very much for having me, Alyssa, and for the AAJLJ. Thank you for all the incredible work that you do. I don't have to tell you all the problem that we've been experiencing since October 7th. We've seen roughly a 400% increase in anti-Semitism across the country. And by the way, for those of you who are supporters of IRA, there can be no clearer demonstration than the events of the last 18 months as to why the IRA definition includes examples of anti-Semitic anti-Zionism, such as holding Jews collectively responsible for actions of the State of Israel, among the list of modern manifestations of anti-Jewish hate. But even now, almost all of the anti-Semitism cases that you see in the news are sort of defensive anti-Semitism cases, right? That includes Title VI at universities or Title VII in workplaces. Title VI is the part of the 1964 Federal Civil Rights Act that makes sure institutions which receive federal funding don't discriminate on the basis of race, color, or national origin. And Title VII does similar things in the workplace, although it also includes religion. The problem with these Title VI cases, and I'll just be frank, is Title VI doesn't actually work. Right? Since 1964, not a single university has ever actually lost any of its funding, and functionally that makes it a dead letter law, to the extent that, just a couple of weeks ago, there was a school in Georgia where there were swastikas found in the hallway with "Kill the Jews," and when I talked to the principal, he said, yeah, we're not really going to bother with an investigation. It's, we're not going to find anything. I said, well, you could find something. You have cameras in the hallway. It wouldn't be that difficult. He said, we're not going to. I said, you already have an open federal complaint at the Office of Civil Rights under Title VI. Don't you want to make sure you don't get another one? And he laughed and said, those don't work. So it's not only that we know it as the lawyers, they know it too, and people aren't scared. Title VII works better, but it's severely limited and it's incredibly case specific, doesn't really make broad law. So after October 7th, we at the National Jewish Advocacy Center at NJAC realized that what we need to do is try and shift to playing offense, right? We needed to expand the toolbox of available remedies to try and protect the Jewish community. And the truth is that a lot of our most famous work actually started with a tweet. I made a mistake of getting much more involved in Twitter after October 7th. I had an account, hadn't really used it beforehand. And on the night of October 7th, in the early hours of October 8th, Students for Justice in Palestine began distributing what they called the toolkit. I don't know anyone here, I'm sure people have seen the SJP toolkit. It remains one of the craziest and most anti-Semitic things I have ever seen in my life. It had Hamas graphics of hang gliders. It said, we are not just in solidarity with Hamas, we are part of this movement. It referred to the fighters as our comrades in blood and arms. It had direct quotes from terrorists, and they were providing people with this toolkit. It was a toolkit to provide them with training and with well done graphics and with PR strategy and with recruitment strategy to try and get impressionable young people on board. But again, the key here was they were very clear. This is not some silly student movement. They were trying very hard to make clear that they were working with Hamas. First of all, they said so, right? We are part of this. And when someone tells you who they are, you should believe them. But then there were also some incredible patterns that started to emerge. For example, Hamas called for a day of rage that week, and SJP responded with their day of resistance. And so, again, I had made the mistake of getting involved in Twitter. And so I wrote a tweet and I said, dear SJP, cosplaying as a terrorist is actually a crime under Section 233(9)(b. Then I explained well over 250 characters, which I later learned you're not supposed to do. But I explained how material support for terror can include things like PR services or recruitment. That tweet went a little bit viral, and CNN asked to do an article on it. So I did. And then the state of Florida called, and the state of Florida said, "Is this real?" And I said, "Yeah." And then the state of Florida said, "Can you do a memo?" And I did. And they defunded all the SJPs in the state of Florida, which created a beautiful test case for us, right? We got to see what the responses would be in Florida before we did anything else. And there were three responses. The ACLU responded and said, well, there's no material support for terror here. There's no money that changed hands. That's just wrong on the law, right? Famous case Holder versus humanitarian law said that even speech, if it's done in coordination with a foreign terrorist organization like Hamas, can be violative of the material support statute. So forget the ACLU. The next response was, I believe, Palestine Legal. And they said, well, these laws that you're suing us under are Islamophobic. Okay, that sounds like an admission of guilt, that you're guilty under the law, but you don't like the law. And that's fine. If you want, we'll take the win and then we'll argue about the law and appeal. And then the interesting one came from the Center for Constitutional Rights. And they said, well, you're suing the wrong people. You're punishing the wrong people. This is not from these local SJPs. That toolkit came from the National Students for Justice in Palestine. And we said, great, okay, thanks for telling us where to point the lawsuit. And so we sued the national organization, National Students for Justice in Palestine, and their parent organization, AMP, in federal court in Virginia. We have oral argument and the appeal in that case in May, on May 7th. But while this was happening, while this was playing out over the course of several months, we didn't wait. We filed other Anti-Terror Act cases. So we sued the Associated Press for buying photographs from Hamas on October 7th. You may remember some of those pictures. Now, we could have sued other news organizations too. They all used the same people, but for the AP, we had a smoking gun email from 5 years back, which said, hey, AP, Hassan Aslaya is a terrorist with Hamas, and you should not work with him. And a lot of interesting things happened in that case. I was doing an interview on Inside Edition the very day that the AP won an award for those photos. And the host in real time said to me, oh, they just won an award. Why is this different, for example, than Holocaust photos, which are very important to memorialize things? And I said to me, the answer is very simple. First of all, no one paid the Nazis to take those photos. And second of all, no one gave them an award for doing so. But okay, that's the AP case. And again, we're working there in the 11th Circuit. Next, we filed a lawsuit against Binance, which is the largest cryptocurrency exchange, for sending roughly $900 million in remittances to FTOs, including Hamas. And we have C-suite emails saying, hey, should we be sending all this money to Hamas? And the answer was, well, we're only sending $900 at a time. You can barely buy a machine gun. Yeah, but when you do it a million times, you can buy a tank. So anyway, the bottom line is that one's interesting because not all material support for terror is ideological, right? Binance isn't really pro-Hamas. They're just about making money, and they would sell their grandmother up the creek for $1 if that's what it took. Our next lawsuit was against UNRWA USA, right? Everyone wants to sue UNRWA, but there's still an open question as to whether or not they have immunity in the courts as part of the United Nations. But we realized early on that they had made a mistake, and they had left their nonprofit, their 501c3, UNRWA USA, unprotected in Delaware. So we sued them there, and we hit them so hard they went dark for a month. They scrubbed their social media. They came back and said, how could we have known? We're just simply a charity. And our answer was, yeah, look at your board that you took off the website. One of them was the Director General of UNRWA in Gaza. And here's the video of her pledging allegiance to Yahya Sinwar. So maybe that's how you know. I know there are people on the call like Richard Heidemann who are doing cases as well against UNRWA USA, really, really incredible and important work. Now, again, as these lawsuits were developing, our case against the student group was also building. And incredibly enough, instead of backing down, they were doubling and tripling down on their support for terror and their coordination with terrorists, especially at Columbia University. I want to take a moment actually and step back and explain to you why these lawsuits are so important. And again, SJP, for example, is just a pass-through organization. There's no money to win here. And on top of that, even if you get them shut down, they'll just walk across the street and start a new organization, which their parent organization actually did, right? IAP was shut down for providing material support for Hamas. So the 5 IAP members who didn't go to jail walked across the street and founded AMP, which later on founded SJP, and they kept going. So why would we fight so hard to get them labeled as material supporters of terror when they're just going to disband and form a new group? And in fact, at Columbia, they did that. They formed CUAD, the Columbia University Apartheid Invest, which is just functioning now as SJP. The answer is very practical. I don't know if any of you have ever been to any of these protests, but if you go to the protests or these encampments, and if you stand in the center, you will see something fascinating, which is that charitably, and I mean charitably, 90% of the people at these protests do not know what river or what sea. They're there either for the pizza or because they have been genuinely misled into thinking that there is something on that side and that they're on the right side of history. So if I can get a court to say, actually, you may not know this, but you have been in bed with terrorists, we may end up actually saving 90% or even 50% of our future, congressmen, senators, presidents, or simply just fellow citizens, our children's classmates, right? It's really important that they know what they're doing so you can save the ones who are not ideologically crazy. Yeah, you're never going to save that 10% in the middle who are leading the charge and inciting, but you just might help the ones who are still salvageable. So I think it's worth the fight. And again, the nice thing about useful idiots like SJP is at the end of the day, a useful idiot is still an idiot and they make idiot mistakes. For example, they hosted a Resistance 101 event where they invited an actual terrorist who came on Zoom and thanked them on behalf of his friends in Hamas. They distributed actual Hamas propaganda. Unless you think that it was not done in coordination with Hamas, again, I kid you not, it literally says on the propaganda, this is an intentional effort done in coordination with trying to spread the movement of the resistance. Unless you're not sure what the resistance was, on the other side of the pamphlet, it said the resistance is Hamas. Okay? So useful idiots make useful mistakes. While this is going on, we brought another lawsuit. You all remember the daring rescue mission in June of 2024, Operation Arnon, when Noah Argamani and the 3 men, Almog Meirian and Andrei Kozlov and Shlomi Ziv, were saved from the Nuseirat camp. Well, what you might not know is that their captor, a man named Abdullah al-Jamal, was also a journalist who was working for an American 501c3 called the Palestine Chronicle. So we sued them for material support. And again, each of these cases is a little bit different, right? So in the AP case, for example, the other side argued and said, well, how do you know he was really a Hamas member and not just an affiliate? I mean, they usually don't carry cards, so it's kind of a strange question. But in the case of al-Jamal, he actually did carry a card. He was literally the Hamas spokesman for the Department of Labor. So we sued them. And in the course of preparing our clients for deposition, Shlomi Ziv told us something really fascinating and important. He said that while he was being held captive in Gaza by Hamas, the terrorists would brag to them and would say, look, we have our people everywhere. And they would show him pictures of, drumroll please, Columbia University. And so we sued the CUAD, which is their version of SJP now, and their leader, Mahmoud Khalil of deportation fame, who's still in the process of being deported. I'll tell you a little bit more about some of the interesting projects that we have going on. That was the first one that really put NJAC on the map, was this Anti-Terror Act line of cases. But everyone again is familiar with the BDS movement, which has made a bit of a resurgence in the last several months. It's moved really from B's to D, from the boycotts to the divestment part of the BDS. And I'll just quickly tell you, we've pioneered a new technique. using what we call, well, you're using shareholder derivative liability suits to go after companies that are engaging in BDS. And the importance of doing that is it takes the ideology out of it. So the case is no longer about why do you hate Israel? It's, hey, you cost the company a lot of money. Now, please explain yourself. I'll give you an example, which is relevant again nowadays. We sued United Airlines after they canceled their flights to Tel Aviv. And we did that because we had evidence that they were not actually doing it for safety reasons, but rather because of pressure from the BDS unions behind them. And within 4 hours of us filing, United resumed their flights. We've developed a suite of innovative language proposals that we call anti-boycottics, right? They're modeled after poison pill amendments in corporate law. And again, we share those with interested companies to prevent them from being co-opted by bad BDS actors. I'll give you a couple more quick examples, and then maybe we can turn to some of the more New York specific things. But here's a couple more quick examples of sort of NJAC innovations that we've been developing. Over the summer, last summer, we represented a client named Kim Summerall, who attended a counter-protest event against Code Pink. Probably know them. They're the extremist hate group you've seen pictures and videos of, usually running around Congress, harassing everyone that they can. But sometimes they also take a break to engage in illegal activities. And this time, one of the Code Pink people saw our client wearing an Israeli flag around her neck, grabbed the flag and choked her with it. Now, again, to my mind, you see a Jewish woman being choked with an Israeli flag that looks anti-Semitic, but both the prosecutor and the judge said, they didn't see any signs of anti-Semitism. And we couldn't let that sit, right? We think it's very important that when anti-Semitism happens, it's labeled properly. Why? The same reason why we have hate crime laws in the first place. Why do we have hate crime laws? Why should you punish thought, is the argument. And the answer is if you attack somebody because you don't like their face, you put that person in reasonable fear. But if you attack somebody because they're a member of a protected group, you put the entire protected group in fear, right? You attack one shul, all the shuls in the neighborhood are scared. That's why we have hate crimes. And that's why we think it's important that when there's an anti-Semitic attack, it is labeled properly so people understand that there's consequences, so the community knows exactly what happened and that the person was held accountable for what they did. Now, if the prosecutor and the judge refuse to do that criminally, how can you do that civilly? There's no civil hate crime enhancement. There's usually no way to do it. So we dug deep and we pulled out a sort of forgotten provision of the 1866 Civil Rights Act, which is now codified in Section 1981. 1981 is usually thought of as a contract claim. It prevents racial discrimination in contracts, but that forgotten line at the end of the original bill actually says, or security of persons. We said, hey, that includes physical security as well. And so we sued for a racial attack under Section 1981, which again has to be based on race. You might ask yourself, are Jews a race? Well, long answer is I don't know. It's above my pay grade. But short answer is whether they are or are not scientifically, whether race is just a sociological construct, it doesn't matter because what the law is really looking for is racial discrimination, which is have you been treated differently because of a real or perceived difference in your race? And the answer to that is clearly yes. And if you go back a few decades, Shari Tula versus Cobb, the Supreme Court already made it clear that for most, at least federal enforcement of anti-discrimination laws, Jews are considered a race. And so in that case, we got what I consider to be the strongest opinion anyone has gotten post October 7th about anti-Zionism and anti-Semitism. Judge Trevor McFadden wrote that attacking a Jewish woman for wearing a symbol that is universally recognized as a Jewish symbol is an overt act of anti-Semitism that has absolutely no place in America. Why is that important? Again, because, for example, when Mayor Mamdani got rid of IRA, right, it's likely now that hate crimes will not be labeled properly when they include anything about Israel. And now we have a civil way of making sure that the labels are applied correctly. The last one, perhaps the greatest real manifestation of NJAG magic in this context is, I'm sure many of you recall how on June 23rd, 2024, there was a riot outside of Adas Torah Synagogue in Los Angeles. And we waited to see what would happen, but it appeared that even after all the heartfelt words that leaders expressed, right, everyone from the president to the mayor said that there is anti-Semitism here and it's horrible, it should never have happened, has no place, yada, yada, yada. But there would be no real consequences for the people who did this. Not a single person was indicted. And we couldn't have that because, again, these people mistake kindness for weakness. And if you don't push back, they will do it again. So we filed Stand With Us Center for Legal Justice versus Code Pink. Stand With Us was our client, alleging that the defendants organized a violent riot outside Abadas Torah synagogue in Los Angeles, and while doing so, they blocked the entrance to a house of worship in violation of both the state and federal FACE Acts. Okay, the FACE Act is the Freedom of Access to Clinic Entrances Act. It's an abortion clinic act, but there's a paragraph 2 which nobody reads. In order to get it passed in the 90s, the Democrats needed a few Republican votes, and they said, fine, if you add a clause which says, or houses of religious worship. That clause has been lying fairly dormant for the last 30 years. And so we use that to say, look, these useful idiots, not only did they block a synagogue, they advertised that they were going to block a synagogue. They filmed themselves blocking a synagogue, and then they bragged about blocking a synagogue. It's $5,000 per violation. They told us how many people there are. Great. Now we have $2 million worth of deterrence. Don't ever do it again. Now, I'll tell you an interesting thing. What's interesting about the FACE Act is that in order for it to be triggered, it requires there to be an act of religious worship that was interrupted, right? So it doesn't just say a house of religious worship, it's a house of religious worship during an act of religious worship. And so we were lucky in a sense, I guess. There was a 1:30 mincha prayer service that day that was interrupted. But the truth is that the riot lasted almost 7 hours, and we wanted to get them for the entire time. So we tried something new. I believe this is the first federal complaint in history to ever quote the Rivash, the early medieval Talmudic commentator. So in this case, the Code Pink lawyer argued, who, by the way, wore a keffiyeh tie to court, very interesting, argued and said, number one, he said, you know, we didn't do anything wrong here. It was just political. There was no endangerment. And when we put up a picture of the Hamas red triangle over the shul, which they had put on their social media, he said that was just an arrow pointing to the shul. It's a regular directional symbol. Why would you think this is a problem? Which even the judge didn't buy that. Um, but they did say, which was an interesting argument, they said, look, this is an aliyah event. Right? You're just selling real estate in Israel. This is a real estate event. It's not an act of religious worship, so it doesn't get FACE Act protection. So we argued, and using my rabbinic training, we said not only is aliyah a mitzvah, a commandment that the Talmud considers equal to all of the other commandments in the entire Torah, but according to the Rivash, the early medieval commentator, and several others, hechsher aliyah, preparing to make aliyah, is also a partial fulfillment of that biblical commandment. And so the judge essentially said, I don't want to touch that with a 10-foot pole. Let's assume the rabbi is correct. And now, for the first time in American history, aliyah is a protected First Amendment right. The DOJ put a statement of interest in their case, saying that this appears to be a correct usage of the FACE Act. And then the DOJ put together a FACE Act team led by John Gross, and they essentially use that Rivash to go and file their own cases. On September 29th, they filed a case for an Aliyah event in New Jersey, the Moshe Glick case. The reason I bring this up now is because if you remember a couple of months ago, there was an incident at Park East Synagogue, right? And when that happened outside that protest, everyone wrote that this is obviously and clearly a violation of the FACE Act, right? Everyone from the NYPD to the DOJ to every Jewish organization. And we take a lot of pride in that because we invented that. And now that's a tool that's in everybody's toolbox. But that story does have actually one other interesting twist, which is Wilshire Boulevard. Some of you may remember that shortly after Park East Synagogue, there was another protest outside of another synagogue in Los Angeles on Wilshire Boulevard, and the DOJ sent their FACE Act team to go and investigate it. While they were out there, they made an arrest of one of the protesters, and they found out she was part of a group called the Turtle Island Collective. The Turtle Island Collective was planning 5 different bombings on New Year's Eve across Los Angeles. And because of this arrest, the DOJ was able to stop those attacks. So I like to explain how, incredibly enough, the Rivash, acting in the Middle Ages, stopped 5 terrorist attacks in early 2026. So that's sort of a little bit of a background on the kind of innovative tools that we're doing. And before I go on to talk about some New York specific things, maybe open up questions for a little bit on that, and then we can talk about some of the New York Mamdani era innovations. So if there's any questions already on that, sure, I'll be
Thank,
interactive.
thank you, Mark. Yes, Rhonda is going to ask a question. Rhonda Lees.
Sure.
Hi, Rhonda.
Hey, Mark. Hi, how are you? Hi,
Good,
Richard.
how are you?
Question for you. Is there a consistent list of outside counsel slash, big law firms that have been representing the quote other side on this? And is that information that people have?
Yes,
Okay. So,
I don't
are
have it
you
on
keep,
me, but I can,
but
I
you're
can.
keeping track. Okay. I, I,
Mhm.
I don't know if you give that out, but I would be very curious to see what
Yeah,
that was.
sure. If they do it,
Okay.
it's on them.
Totally get it. Okay. Thank you very much.
Sure.
Thank you for all you do. Okay.
Thank you.
Thank you, Mark. If anybody would like to ask a question, you feel free to unmute yourself and you can just ask
I've
directly.
just got a question. It's Ari. Hi, Mark.
Hi.
Ari Jacob. I'm actually from Australia. I probably shouldn't have been in this meeting, and it's far more sophisticated for me and my situation here. But my question is, you're talking a lot of stuff I've missed out that you brilliantly explain and eloquent, the whole, especially the part with the flag was being strangled. I didn't quite understand about the what the judges said because you're quite fast and and I'm trying digesting and trying to convert certain words to Hebrew, so you can imagine. I just want to know if any of the laws that you managed to pass in the US have any application in Australia. Like any of that can be used as not as precedent because there are different rules, but do they apply for Australia? Because there's a lot of anti-Semitism going on here.
Sure. Well, very quickly, what the judge said in that case, the law that we used specifically only applied if what happened was based on race. And in letting us use that law, the judge said clearly this was based on race. It was an anti-Semitic attack based on race. And that was important because Code Pink said, oh, it was just Zionism, it was just an Israeli flag. And the judge said, yeah, attacking a Jewish woman for wearing an Israeli flag is an act of anti-Semitism. And that was an important step for us. In terms of Australia, I will just share with everybody that NJAC, the National Jewish Advocacy Center, also sponsors and runs something called IJAC, the International Jewish Advocacy Center, where we have affiliates in 9 different countries, including Australia. In Australia, we work with Arsen Ostrovsky. We used to work with him when he was at ILF in Israel, and now we work with him while he's in Australia. The answer is that a lot of the times the exact laws don't apply, but the principles do apply. We've been able to help with cases in Canada, in the UK, in South Africa, applying some of the principles we've developed here to fit the laws that are in place there. So if there's specific questions that you want, I'm happy to try and work with you or you and or Arson on that.
But the reason I'm asking because I'm taking a strata manager. I don't know what you call it in the US. They stated managing the building, who called me directly in my face. She doesn't even know me. She never even met me. And it's all captured on CCTV of the building. She called me some of the worst words you can imagine. And I'm 6'4", and I can cause a lot of damage. I've been in the army and what have you. And I've kept quiet, and she's actually chasing me with hand movement like you would not believe. And I don't know whether I just bursted, like amazing. Obviously, it was a learning behavior. But to cut a long story short, I went to complain to the police. They just didn't even want to know about it, the West Australian police. And I couldn't believe it. And I'm telling the policeman, I mean, if it was the other way around, you probably would arrest me. I mean, the natural thing for me to do is just slap her for insulting me like that. And she did it in front of a 12-year-old uh, girl. But to cut a long story short, I just left the police. I was very disappointed. I went to the magistrate court and I filed, a misconduct restraining order. Now, I asked for the CCTV, through subpoena. He can clearly see that it was tampered with, literally tampered with. I was removed from the whole thing, and everything is sort of slowed down. And police didn't want to know about it. It just you're absolutely on your own. And struggling with another language, it's another problem. But I was just wondering because I've got now, I was you heard of just a second, I'll tell you this is it was Lord. Excuse me 1 second. I just tell you the name. I'm just got too many things happening. It's quite late here as well. Normally I'm in bed hours before that. So um, Rabbi Lord Jonathan Sachs
Hmm.
from England. I know you've heard of him,
Sure.
and just talking about the exact same thing, which I'm experiencing. So this is they call me with you know upfront with anti-Semitism, but now they don't have to do it. It's
Um,
they don't
I'm
have to
so
call me
sorry.
with it.
I'm so
Yeah.
sorry, Aryeh, to
I don't
distract
want
you.
to, I'm sorry to get into
It's
detail. I'm
okay.
very
Maybe
sorry. I
maybe
know
you
this
can,
is
because we have some other questions. So maybe you
yeah. I
can try to
just I
follow
just
up with
want
Mark
to I
later.
just
Thank you,
wanted
Aryeh.
to
Aryeh,
say
please, we
if
really need to move
yeah,
on.
I just want to say about the actual law that I can apply here using from the US if I'm learning anything from this. I'm sorry to take some of your
Well,
time.
look,
I'm
yeah,
sorry.
you know what we'll do after these questions, I'll tell you about Section 1983, and I think there's an equivalent in Australia, and we can talk about that. And you can feel free
Thank
to follow up with me after.
Yes,
All right.
thank you, Aryeh. I'm
All right.
sorry. We just need
Sorry
to.
about it. Sorry. I'm very sorry.
Richard. Yes, please, Richard Fulton. Thank you.
Thanks so much. Thank you, Mark. Had the pleasure of hearing you speak a couple of days ago at the Antisemitism and the Law Conference in New York. And I want to follow up on a question I asked at that point. There is, of course, the Church Arson Prevention Act, which is a criminal law that was expanded several years ago to include religiously affiliated institutions like community centers, which are not covered, as far as I know, under the FACE Act. So my question to you, and I think at the time you indicated you are beginning to look at the Church Arson Prevention Act. I wonder if you could expand on that a little bit and tell us about what your thinking is and what can be done to assure that institutions that can't probably be classified as houses of worship would receive the same kind of protections that churches and synagogues receive under the FACE Act.
Yeah, the short answer is unfortunately or fortunately, there's no civil aspect to it. There's nothing that I can do about it. I know that the Department of Justice is is looking into whether or not they can bring those cases. There are some other, again, within the Church Arson Prevention Act, there are some other caveats I think that they've struggled with, but I know that the DOJ is actively looking at doing it, and they're the only ones who really can.
Thank you.
Sure.
Thank you, Richard. Does anybody else have questions for now? Or I know Mark also mentioned that he would move on to discuss some other more New York-based lawsuits, if I understand, correct?
Yeah.
Okay, wonderful. So let's move on there, and then we'll take some more questions.
Okay. So, and this will build a little bit off of Ari's question, I think. Let's talk a little bit about Section 1983. Section 1983 of the Civil Rights Act of 1871. It's one of the great, really, enforcement tools of American democracy. It was enacted right after the Civil War to curb local officials who were turning a blind eye to post-Civil War violence against minorities. And today it's really a lifeline for citizens when the government itself becomes the source of discrimination. So Section 1983 doesn't create any new rights. It allows private individuals to sue state or local officials who, under the color of law, deprive them of rights that are guaranteed by the U.S. Constitution or by federal statutes. So, for example, we have a case in North Carolina, our Gluck case, where we sued the police department for depriving people of rights under the First and 14th Amendment. There was a counter protest where a group of elderly Jews were assaulted, and the police essentially turned a blind eye. So what does it mean in the context of, say, a New York? Imagine if, for example, a mayor or a city agency uses their power to target Jewish citizens or to suppress Jewish expression or to penalize Jewish organizations in ways that Mamdani has said he might actually do. Section 1983 is the pathway for how you get to federal court and to accountability. So what are the elements of a Section 1983 claim? You have to prove four essential things. Number one, that the defendant acted under color of state law. Number two, that the defendant's conduct deprived the plaintiff of a federal right. Number three, that there was a causal link between the two. And number four, that the plaintiff actually suffered an injury. So what does it mean someone's acting under color of state law? It means they're exercising authority that's derived from their state or local office. That includes mayors, but it also includes agency heads or police. It even includes private entities that are performing public functions at the government's direction. What kind of evidence would you need to show that the person in question was acting under color of the law? Things like official correspondence or permits or funding records or any directives showing that the conduct occurred in an official capacity. Now, here's an interesting question. What if the official action taken is itself unlawful? Can you still say that the person who did it unlawfully was acting under color of state law? The answer is yes. Supreme Court in a case called Monroe versus Pape in 1961, that was a case where Chicago police broke into a home without a warrant. So what they did was unlawful. And the question is that considered acting under color of state law when state law didn't allow it? The Supreme Court held that yes, the misuse of power granted by the state also qualifies as acting under color of law, even when the action violates state law itself. Okay, so next there has to be a deprivation of a federal right. What might that look like in an anti-Semitism case? A number of examples. So it could be, for example, an equal protection violation if there's intentional discrimination, right? You'd have to show that the members are a protected class, whether it's a religious or an ethnic identity, Jewish or Israeli. They were treated differently from similarly situated comparators. There was a discriminatory intent that was a motivating factor, and they were harmed. So again, like in our Gluck case, where they only protected the protesters and not the Jewish counter-protesters. It could be a First Amendment, like speech or free exercise, viewpoint discrimination, right? Government can't favor or disfavor speech based on an ideology. So imagine that, the mayor denies a permit for a pro-Israel rally, but approves for others. That would qualify. It might include a due process violation, right? There's procedural and substantive due process. Procedural means that you're depriving individuals of property or liberty, which in our case could include permits or funding opportunities without notice or hearing. And substantive is conduct that's so arbitrary or egregious that it, quote, shocks the conscience. I know that sounds like a super high standard. It's actually not that high of a standard. In County of Sacramento versus Lewis, in 1998, the court held that police conduct that's deliberately indifferent can violate substantive due process. Again, I'll go back to our Gluck case, right? So if they're deliberately indifferent, that is enough to shock the conscience. What does that look like in an application? Again, imagine you have a municipal administration where the mayor denies a permit to a Jewish cultural event like an Israeli Day Parade, right? So bottom line, Section 1983 is how you make sure that public power does not itself become an instrument of discrimination. Okay. We already talked about the FACE Act case. I will tell you that another thing which we've started doing a lot of are defamation cases, right? Defamation cases involve a false and defamatory statement published to a third party. Fault, right? When it's a public official, there needs to be actual malice, it means knowledge of falsity or reckless disregard for the truth, and harm. If you want to federalize the claim, you have to bring it under, we said before, Section 1983. I'll give you an example of a defamation case that we brought in the anti-Semitism context. I'm sure you're all familiar with our good friend Francesca Albanese, the former special reporter on Palestine for the United Nations. I say former because her mandate ran out a year ago and was never officially brought back, which is why the United States felt comfortable sanctioning her because she's no longer really employed by the UN. She defamed a bunch of people, including 2 Christian charitable organizations. And so we sued her for defamation. And like the coward that she is, she has been evading service at every opportunity, knowingly and willfully evading service. We found out a little while ago that she was going to be giving a speech in person at the Nelson Mandela Foundation in South Africa. And so we very quietly spent a couple of weeks going through all the right procedures, filling out all the right paperwork, going all the way up to the Ministry of Justice and getting a signed letter allowing us to serve her in person at that event. We caused somewhat of an international incident. The country of South Africa actually apologized 4 times for letting this happen to her. First, they said that it was a forged letter. So I posted the actual signed letter from the Ministry of Justice on Twitter and said, the ball is in your court. We'll see you in ours. And then they said, well, it must be that a Zionist spy got into the government, probably got somebody fired, unfortunately. Bottom line is it was valid. So we're in court now trying to prove that service was effective. The ultimate goal in that case, a little bit of poetic justice, Francesca Albanese has a house right outside of DC. We want to take her house and we want to donate it to victims of Palestinian terror and open up the Francesca Albanese home for victims of Palestinian terror. I think that would be a nice way of doing that. But you can also imagine a more local case, right, where perhaps someone acting under color of state law, a mayor or a police officer or an administrator, might actually defame people by talking about things they haven't done, accusing them of war crimes or of genocide or of things like that. So that's another thing just to sort of have in your toolbox. Any questions about those?
So,
Mhm.
Mark, let me ask you,
Yeah.
thanks so much.
Mhm.
Is there, I know you have a lot of, I imagine that you have a number of potential lawsuits based on actions of the current mayor administration. Is there a way that our membership might be able to find out about more of those, and if we could potentially get involved as co-counsel in another respect?
Sure. We are always looking for good people to partner with. I know that you have a database, right? And so Lydia, our COO, is on the webinar as well. Hopefully we can coordinate. And, we're always, depending on the case, we're looking for people who are barred in a particular jurisdiction, who have expertise in a particular field, et cetera. We can certainly share that with you and run it through your database. And if there are people who are willing, ready, and able, we'd be willing, ready, and able to work with them.
Wonderful. Hopefully, at least some of the people on this call will be interested. Lydia wrote the contact information in the chat, and I'm also happy to share that again with everyone. So one other question. Let me see. So from a policy perspective, I mean, we have certain laws federally and in states to protect Jews, of course. But from a policy perspective, what would you potentially change, say, if you could change that or add something to the current legal framework that would help protect Jewish communities? Have you thought about the kind of potential policy changes that would be helpful for us?
Well, we're involved heavily in New York in the buffer zone legislation fight. And we've written two very long, very detailed memos explaining why the proposals for buffer zones around places of worship are not only constitutionally sound, they might even be constitutionally required to protect and make sure that people's First Amendment right to religious freedom is not somehow deteriorated. There's from a policy perspective, what we really need to do is make sure that people understand the First Amendment better. The First Amendment is not some pass to threaten, harass, intimidate, or otherwise disturb the rights of others. It's just completely misunderstood nowadays. And what you often see academics do when they try to make this argument a little bit more sanitized is they look away from the facts and they argue that, we have to protect all of these violent protests because what if, God forbid, our trying to protect the victims ends up encroaching on someone else's free speech? And that's an inversion of both morality and the law, right? Your free speech rights don't get to trample over someone else's rights to physical safety and security, or the right to attend a university unmolested, or the right to attend an act of religious worship without having to go through a crowd shouting threats and hurling insults at them. It's just an inversion to think that free speech, what you're actually seeing is the free speech rights swallowing up the rights of others in a complete overbroad overcorrection of protection of speech. So I'm a free speech advocate. Absolutely. Protests are important. They're important. They're an important part of what makes our democracy so great. But there are rules for what constitutes speech, and there are limits when it crosses over into invidious discrimination and harassment. We need to respect those rules with reasonable time, place, and manner consideration. So policy-wise, what we need to have are clear, applicable rules that apply in every situation to every group, regardless of ideology, and that are actually consistently enforced with real guidelines and timelines and published records and accountability. So that's the short answer. And then again, we've been a big proponent. I wrote the model bill for the IRA bill that's now used in many different states. And I very firmly think that having a definition of anti-Semitism is incredibly important. What makes it so hard for people to see anti-Semitism charitably is that they don't know what it looks like, right? They don't know what it looks like. A recent survey found that almost half of adult Americans don't know what the word anti-Semitism means. And that's the ones who are willing to answer that question on the record, honestly, right? Probably a lot more who don't know what it means. So charitably speaking, you need a definition in the law to make sure that everybody understands what it is. Less charitably, you need to hold people accountable so they don't look away when there's clear and blatant anti-Semitism in their face. One of the easiest things when you're trying to get something done and someone wants to not do it is to say, I have vague First Amendment concerns, right? I often push back on politicians or legislators and say, what are your First Amendment concerns? Let's talk about them. They don't want to talk further than that. I have vague First Amendment concerns. They don't say the word vague. I have First Amendment concerns, right? Push back hard on that because there are no actual First Amendment concerns for IRA bills that are drafted properly and constitutionally, and there's no reason why they shouldn't be required, right? An authority is making a determination to look at the world's gold standard definition of antisemitism for contextually relevant evidence to make sure that what they're seeing is being labeled correctly. And the danger of not having IRA is evident in New York. So I'll tell you the case of Saddam Massoud, right? Saddam Massoud, a member of Within Our Lifetime, which is grown up SJP, violently attacked three different innocent American Jewish men on three different occasions, put one of them in the hospital. When they got to court, there's no definition of anti-Semitism in New York, and so, or federally, and so the judge didn't have anything to compare it to. And Sada's lawyers, knowing this, argued that what he did was not anti-Semitism. No, no, they said attacking three innocent American, visibly Jewish men. He didn't do it because he's an anti-Semite. He did it to promote, this is a quote, promote social and political goals about Palestine. And yes, he went too far, but it was really just a political fight. Again, walking up to innocent Jews and attacking them was a political fight. And the crazy part is that might have worked, right? There were other states in the same time frame where arguments like that actually carried the day. Thankfully, in this particular incident in Saddam Massoud, the prosecutors got his signal messages, which he didn't realize they could do. He thought they were encrypted. And in the messages, he said to his friends, hey, when we go hunting Jews, don't say Jew, say Zionists so that my lawyer can get us off. Right? The exact academic argument they're making. So that sort of highlights the importance of having a definition so that lawyers, again, these people should be disbarred for doing that, but so that lawyers can't make those kinds of ridiculous arguments and that judges have a text to turn to say, no, actually, that holding Jews collectively responsible for actions of the state of Israel, that is in fact a problem. You got policy-wise, I would also make it clear that Zionism, whether it's used as a proxy for Jew or whether it's used to signify the national origin of the Jewish people, is a protected class. It's really interesting. Most anti-Zionists cannot define the word Zionism, and certainly most anti-Zionists don't know what the word Zion is. So how can you be anti-something that you absolutely couldn't do? The interesting question is, ask them what Zion is, right? Zion's not an idea. It's not a political thing. Zion is a place. It's a mountain in Jerusalem, Israel, where Jews are from. We are Jews from Judea. We're Zionists from Zion. The belief in Zionism, which is that Jews have a right to self-determination in their ancestral homeland, right? The key of those last two words, ancestral homeland. It is the quintessential national origin movement, even devoid from the religious aspects. So I'd make sure policy-wise that Zionism is protected as an important facet of multiple parts of Jewish identity. I hope that answered your question.
Thank you. Yes, it was definitely a start. Of course, there's much more to discuss and to explore. So Daniel Pollock just asked, you were a witness at the Civil Rights Commission hearing 2 weeks ago. All the other legal scholars on the panel said that defining anti-Semitism is itself a false path. I was very troubled with the Jewish witnesses at that hearing. What was your reaction?
I was also very troubled, but not surprised, unfortunately. I have very little nice to say, so I won't say very much about that. But what I will say is that if someone is pushing hard against defining anti-Semitism, you have to ask yourself why, right? All of these bills that define anti-Semitism, the only people that it could possibly hurt are people who are planning to do illegal actions and target victims because of their identity. Let's just take a step back for a second, right? A lot of what these arguments were people who hadn't actually apparently read the IRA definition because they were saying that the IRA definition, prohibits criticism of Israel. Literally in the IRA definition, it says criticism of Israel like that leveled against any other country is not anti-Semitic. And they also said that the IRA definition makes things automatically anti-Semitic. It literally doesn't. First of all, in the bill itself, it says that all the examples could, this is a quote, taking into account the overall context, be anti-Semitic, right? It doesn't say they're automatically anti-Semitic. It says they could be because of people like that who say that they never, ever are, no matter how offensive and troubling they become. Also, the bills themselves have additional caveats, right? Again, most of the bills incorporated so far in a Title VI context or a hate crime context. You can say whatever you want, however abhorrent, about Jews or the Jewish state, and none of the bills defining them have anything to do with that. They're only triggered by illegal conduct, right? Title VI itself doesn't deal with speech. It only deals with unlawful conduct. Hate crimes don't deal with speech. They deal with unlawful conduct. So the only reason you'd be opposing this bill, to my opinion, and it seems pretty clear to me, black and white, is if you would like the ability to commit unlawful acts, whether it's under Title VI or whether it's under hate crimes, target people because of an aspect of their identity and not be held accountable for it. So I have a lot of trouble with the people who are pushing back against those bills, and I would push them. And I tried to at the end. They didn't want to let me answer the question. In fact, the guy said, I only want to hear from the people who are opposed to IRA, which was an unbelievably open statement of where he stood on the issue. But I sort of forced my way at the end to say it's important that you actually read the definition and the bill before you offer commentary.
Thank you, Mark. So I just read that hate crime is up in New York about 152%, if that might be correct. But because of the way that that hate crimes are now being, I guess, considered and prosecuted, that number will likely go down greatly. How how is the administration doing that, and are they partnering with the NYPD to make this happen?
So the mayor doesn't get to define what a hate crime is, but he has a lot of influence, right? What he can do is make sure that certain ones are prioritized, or what he can do is remove the requirement that the authority figure considers anti-Semitism, the global definition. And it's important because at the end of the day, both universities and police departments are incentivized not to have anti-Semitism. Right? It doesn't look good for them to have hate crime charges. It doesn't look good for them at a university to have anti-Semitism complaints. And so what they'll do is look for any excuse to get rid of it and any excuse to say it. I have seen, I can't tell you how many, literally dozens of cases where there were swastikas drawn at universities or schools and they were not labeled anti-Semitic. And they say, well, weren't sure it was a swastika. We thought it might be a Hindu peace symbol, at the wrong angle. And I said, but it says it says F the Jews underneath. And they said, oh, that was, it's just a prank. I said, but it says kill the Jews. That's just boys being boys. I was at a high school in Johns Creek in Georgia. Real story. People will do anything they can to not label it. And so what the administration has done so far is that they have given tools to people who don't want to see hate, whether it's for ideological reasons or simply for their own stats. They don't want to have that on their record. They give them a chance to not have to report it.
And how do they do that? And you say give them a chance.
Well, when you remove the requirement that they consider the IRA definition, for example, right? Anytime that there's an attack, and it's, we have two cases like this right now. So if anyone's interested in helping on these cases, people were attacked for being Zionists, right? And at being at a counter protest, physically attacked and hurt. And they tried to file hate crime charges, and so far it hasn't worked because they say, well, we don't want to get involved. It might just be political. I had a case in Georgia, for example, right after October 7th. It was the University of Georgia. Kid was walking to class and SJP surrounded him, threw him to the ground and said, we're going to kill you, your family, and all Israelis. The kid is not Israeli, just visibly Jewish, wearing a yarmulke. And this is a true story. When we went to the police station, the chief said they're not going to bring a hate crime charges. Why? He said Israel, not Jew. That was astounding to me. And that story really helped us pass the IRA bill in Georgia so that police don't have the ability to make that kind of ridiculous statement.
Wow. Thank you. And actually, Alan Nesbitt, one of our board members who is based in LA, had written that he was actually at the counter protests at both of those LA events. So, Alan.
We have 2 minutes left. If you want, I can just tell you about another interesting, innovative legal strategy that we are doing now. And the reason I saved it for the end is because, unfortunately, you'll see why I can't go into too much detail. But some of you may remember in the beginning, I said that Title VI doesn't work. But the idea behind Title VI is a good one because at the end of the day, as the Bible says, Kesef Yanes, money answers everything. People respond to the threat of possibly losing money. The problem with Title VI is there's so many infirmities along the way and so many chances for them to stall and to ask for help and to say they'll do better and then never do better and then never have any follow-up. It doesn't actually lose anything. But what we've been doing is filing key tom actions. Some of you may be familiar with key tom actions. They're a kind of lawsuit that allows you to step in as a relator in the foot of the government and say, hey, government, these people have been taking money from you under false pretenses, under the False Claims Act, and that they're not entitled to. Do you want your money back? And the government has a chance to say whether they want to take the case or to let you do it for them as a relator. So what we have been doing has been going back to the school districts and the universities that have signed resolution agreements and that have not kept them, because now it's no longer a Title VI question. Now it's a straight contractual claim. You said there was a hostile environment. You were going to do X, Y, and Z in order to protect people and get rid of that hostile environment. You didn't do X, Y, or Z, but you took the federal money. That is a False Claims Act question, and so those have to be filed under seal, so they're not public yet. But we sue them and go to the government and say, "Do you want your money back?" So it's the idea behind Title VI without some of the infirmities. And if people are interested in working on those cases, unfortunately, there are a number of them as well.
Brilliant, brilliant strategy. Thanks, Mark. Hopefully, we might get some people here who can try to join in that. Thank you so much. So as we come to a close, I want to, of course, thank Mark Goldfeder for an excellent and extremely thoughtful and evocative discussion today. We're so grateful, Mark, for your time and your work, your insights. Incredible. Even though Lydia just left, she has been so wonderful and instrumental in making this happen. So Lydia Musher, the CEO of NJAC, I want to thank her. I'll thank her again after. So for our AAJLJ members, I encourage you to reach out to NJAC and explore ways to get involved in the work. There seem to be many opportunities for lawyers to contribute their expertise. So
Too many opportunities. We're the rare law firm that would love to go out of business, but until that happens, we're happy to work with everyone.
Unfortunately, yes. And I do want to just acknowledge some of our board members here. We have Alan Nesbitt, who you just saw, and Ron DeLees, and I'm sorry, Richard Huberman, and that we did just have Richard Heidemann, our POJ awardee. I believe he may have had to sign off. But thank you to everyone for joining. I invite everybody to also become a member of the AAJLJ. If you're not yet a member, we'd be delighted to have you join us. You can check us out and join at AAJLJ.org. And finally, please mark your calendars for our next program, which will be March 26th. It'll be featuring Michael Reed, who will speak on a case called Sander versus Westchester Reform Temple. It involved the firing of a religious school teacher who authored an anti-Zionist blog post. So join us on March 26th. And thank you again for everyone for joining us today. Thank you again to Dr. Goldfeder. Take care. Bye-bye.
Thanks, man.
Thank you.